Right. The key legislation in data protection, there isn't too much legislation here, is the Data Protection Act 98 and the fantastically entitled Privacy and Electronic Communications EC Directive Regs 2003. The two of those regulations work together. There is quite a bit of overlap between the two. Any business trading online is going to need to take account of both of those and to comply with both. Okay, so Data Protection Act, what does it apply to? People think, well, data, obviously. That's not actually true. It applies to what's called personal data. Personal data, as it says on the screen, relates to a living individual who can be identified from that data, or from any other information that you're likely to come across if you're controlling that data. So it's if somebody's named in it, or from the data that you've got, you can work out the specific identity of a person. That's a person that's distinct from a company or a business. You might say, where's the line with sole traders where the individual is the business? But it's a grey area. If the data is not personal data in that sense, then the Data Protection Act has no effect. Throw it in the bin. So if that's personal data, well, what is data? Data in this sense is anything that's computer processed, which I suspect most of you guys are going to be dealing with data of that sort, or anything that's part of a relevant filing system or accessible record. I think the distinction there is it's not going to be something, if you're just holding a general file of bits and pieces of paper on people, that's probably not going to be structured enough to be a relevant filing system. But the key point, I think, if it's computer processed, you've got computer records, it's going to fall within the Data Protection Act. There's then sort of a subset of that which is sensitive personal data, which, as its name suggests, is personal data that's of a particularly sensitive type. So if you've decided something that you've got is personal data, Data Protection Act is going to apply. Next question, is it sensitive personal data? And if it is, special rules apply. Now, generally, it's illegal to hold any of this kind of stuff on other people, unless you can fit within a specific exemption or exception, which I'll come to shortly. So if you're dealing with any of that type of data on a regular basis, then you've got to be very careful and make sure that you fit within the rules on that. The Data Protection Act is based around 8 data protection principles, and you'll see lots of references to data protection principles. They're the main planks of the Act, and basically it's these 8 principles that govern data protection law. Now again, I could talk quite a while about each. There are books which just look at the 8 principles. I know, I've read some of them. I wouldn't recommend that you read any of them unless you suffer from insomnia, in which case you might well want to. Just to make you aware of them, the key one is number 1, fair and lawful processing, which I'll explain a little bit more detail shortly. The one that I just want to flag up particularly in this context is number 8. Data is not to be transferred to other countries that don't have adequate protection. That again is a topic in itself, because every country in the world has, well, I was going to say has some data protection law, but that isn't actually true. America being a key one that doesn't. Because this is all EU-driven law, the presumption is that if you're transferring to a country that has data protection law that's equivalent to EU law, it's probably okay, it's going to comply. If it's a country outside that, then you may not be allowed to do it. And you can get into all kinds of tricky situations with locations of servers and that kind of thing, because if your data's going via a server and then coming back again, that is actually deemed to be a transfer out of the country, and you might fall foul of the Data Protection Act. If you think that's going to apply to you, it's something to discuss with us separately, to be honest, because it is such a complicated area. If you're collecting data via your website, if you're going to trade online, or any kind of survey, anything you might be doing on your website, then you're going to be collecting data from customers, people who visit that site. For example, if they're needing to input the name, address, details in order to buy something from you. You've got to make sure that you structure your website to ask the right questions so that you're complying with those 8 principles that we just... The Data Protection Act says, and I quote, that when processing regard has to be had to the method by which the data is obtained, including in particular whether any person is deceived or misled as to the purpose or purposes for which the data is to be processed. So what that basically means is anything that you're collecting and processing, you have to do it in accordance with the purposes that you've said you want that data for. How I sort of phrase that is to say, tell the person who's data collecting, tell them what you need, why you need it, and then stick to that reason. So don't go and use it for anything else that you might want. You have to be upfront and say, this is the information that I require from you, this is why I want it, and I won't do anything else with it. And in fact, if you wanted to do something with it subsequently, you would need to seek specific consent of that individual. You also need to provide, as I've got on there, provide the data subject with basic facts about who you are as the person collecting the data. And you do that by way of a fair processing notice, which gives the identity of the data controller, the identity I've got on there, the identity of a representative, if any. That's only going to apply if the data controller is located outside of the UK, when you would then have a representative in the UK for the Data Protection Act purposes, so probably not relevant here. You also need to give notice of the purposes for which the data is to be processed. For example, direct marketing. Are you going to want to use that data to then market to that individual? If you are, you've got to tell them up front. And the great lawyer's catch-all provision at the end there, any further information that is necessary in the circumstances. Examples might be, are you going to share the data with somebody else? You're going to pass that information on to someone? If so, have it in your notice, have it on your website. If people are filling in forms on your website, are replies to any questions mandatory or voluntary? What happens if they don't fill in a particular bit of information? Is that going to cause a problem with what they're actually applying or asking you to do? And also, if they have, as they should have, a right of access to the data and a right to rectify the data that you're holding, again, you need to tell them in the fair processing notice. I'm sure we have people in our commercial department who can prepare fair processing notices for you if you need one on your website. Forgive the plug. Ellie, for example, perhaps.
Just copy yours.
That has been done. Wouldn't recommend it, but there you are. Would that be legal? Copyright question.
No.
There you go. If you look at, it's interesting. If you look at terms and conditions and statements, you'll find they're all probably about 90% the same. Yeah, because clearly people do that. It's called a precedent.